You brought a lawsuit against your doctor claiming that he was careless, causing you significant harm and injury. Why is it that during the course of your lawsuit, the defense wants to have you examined by a doctor of their choosing in what's known as a physical examination? You want to know the answer? Come join me for a minute as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so you brought a lawsuit against your doctor claiming that he was careless and that his carelessness was a cause of your injury and that your injuries are significant and permanent. During the course of your lawsuit, the defense will want to go ahead and have you examined by a doctor of their choosing. The defense calls this an independent medical examination. Well, I have to share something with you. There is nothing independent about this medical examination. The doctor that they choose is being paid by the defense, either the insurance company or the defense attorney. Okay? So there's nothing independent about it. And there's only one real goal about why they want you examined by a doctor of their own. Because they want to do everything possible to totally minimize or eliminate the fact that your injuries are significant. They want to go ahead and examine you by a doctor of their choosing to show that your injuries really are not as bad as you claim them to be. Now you might be thinking, how is that possible? How could a doctor go ahead, examine me, and say, wait a second, I know I have significant permanent injuries. All of my treating doctors have told me I have to live with these injuries. How is it that this one doctor who's going to examine me for a few minutes is now going to come to the conclusion that my injuries are not significant and they're not permanent? Well, that's the problem, isn't it? Because their entire goal is to try and minimize and reduce your injuries, to show to the jury, ultimately, if your case goes to trial, that, hey, the claims you are bringing are not as significant as you claim them to be, or at least the injuries that you're claiming are not as significant as you claim. And the only way they can do that, the only way they are permitted by law to do that, is to bring in their own doctor who's examined you for a few minutes to say, hey, listen, I examined this patient. This patient's a malingerer. This patient's making stuff up. I don't agree with any of her treating doctors. That's exactly what they do. This doctor will now come into court and likely go ahead and explain why your injuries are not that significant. The defense is not satisfied with your own treating doctor's medical records. They're not satisfied with the operative reports by the surgeon who operated on you. Now that doesn't make much sense, does it? Well, it does if you're looking at it from the viewpoint of how can we do something to try and minimize or reduce the extent of this person's injuries? How can we show in some regard that your injuries, the injured patient's injuries, are not that bad? The way they do that is by having you seen by a doctor of their choosing. Now here's something fascinating. The doctor that they're going to send you to is only going to examine you for a few minutes. He's going to examine you maybe 5 minutes, 10 minutes, 15 minutes, a very short period of time. He's not going to see you over a period of days or weeks or months or even years. Unlike your own treating doctors who are going to see you on a regular basis and will be able to see how your condition has changed from the very beginning up until the point in time where you are now coming up for trial. That's an incredible thing for a doctor to be able to see. It's extremely important for a doctor who treats you to be able to see how your condition has changed from the very beginning up until the time now, in the present time. This doctor is not going to see you multiple times that they choose for the defense. Instead, he's going to see you one time. He's going to obtain information from the defense attorney about your doctor's medical records. He's then going to read those records and then write a report detailing his conclusions. And I guarantee you that his conclusions are going to do everything possible to minimize the extent of your injuries. Isn't that fascinating? So now you're going to have your treating doctors come into court to testify to explain how your injuries are significant and or permanent. And then the defense, in all likelihood, will call the defense doctor to come in and testify to say, yes, I examined Mrs. Jones on this day, and I spent X number of minutes examining her, and I reviewed all of her records, and it is my considered opinion that she doesn't have any serious or significant problems. And she can go back to work, and she can go do her daily life activities. That's what happens during these examinations. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what really happens in these medical malpractice cases here in New York. You know, I understand you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, @oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.